Good afternoon, Chairman Schatz, Vice Chair Murkowski, and members of the committee. My name is Doreen Blaker, and I have the honor of serving as the president of the Keweenaw Bay Indian Community. Thank you for the opportunity to provide testimony on S-195, the Keweenaw Bay Indian Community Land Claim Settlement Act. This bipartisan bill would compensate our tribe for the unlawful taking of our treaty-protected reservation lands and confirm title for the current landowners. This bill is a testament to how working in the spirit of collaboration can lead to positive results. Today, the Keweenaw Bay Indian Community is located on the Lance Indian Reservation in Baraga County on the shores of Lake Superior. In the mid-1800s, the western frontier continued to expand, and the federal government took a great interest in the mineral resources of the Upper Peninsula. This led the United States to enter into the 1842 and 1854 treaties of La Pointe with our ancestors. The 1842 treaty addressed mineral rights and provided for the cession of lands to west and south of Lake Superior. However, the terms of the 1842 treaty specifically reserved our rights to continue to occupy, hunt, fish, and gather in our homelands within the ceded territory. In the 1854 treaty, we ceded additional lands in Michigan and Wisconsin in return for the recognition of a permanent reservation, the Lance Indian Reservation. Unfortunately, the promises made to our people in these treaties were not kept. Despite the protections of the 1842 and 1854 treaties, our reservation lands were unlawfully seized and transferred to the state of Michigan through the 1850 Swamp Land Act and the 1852 Canal Land Act. Shortly after signing the 1854 treaty, the state of Michigan began demanding that the federal government transfer title to wetlands within our reservation based on the Swamp Land Act. For many years, the federal government flatly rejected Michigan's contentions, and the United States General Land Office refused to transfer title. The Interior Department informed Michigan that its submission of a swamplands list did not obligate the U.S. to transfer these lands because they were already reserved for our people. The Supreme Court confirmed this in 1906. However, the GLO transferred 2,700 acres of reservation swamplands to the state of Michigan between 1893 and 1937. These transfers violated both federal law and the creation of our reservation through the 1854 treaty. The community has never been compensated for this unlawful taking. Further, through the Canal Land Act, the community was dispossessed of more than 1,300 acres of the Lance Indian Reservation. The Canal Land Act was intended to help finance the construction of the Sault Ste. Marie Canal. The United States had granted Michigan the right to select 750,000 acres of federal land within the state to defray the cost of construction within the canal. The state identified and selected more than 1,300 acres within our reservation. Without explanation, the Secretary of Interior approved Michigan's land selection within the Lance Reservation, even though those lands were already set aside by the 1854 treaty. Our tribal council sought to advance these claims and the justice our tribe is due through non-adversarial means so that we can maintain harmony with our neighbors. The community presented our claims to the Interior Department, showing that the taking of our reservation lands violated the Fifth Amendment to the Constitution. In December of 2021, the Interior Department stated, "We have carefully reviewed pertinent documents, including the tribe's expert reports, and have determined that the tribe's claims to the swamplands and the canal lands have merit." To resolve these long-standing claims, the tribe has been working closely with our neighboring communities, the state of Michigan, the Interior Department, and our congressional delegation. Our efforts resulted in the Keweenaw Bay Land Claim Settlement Act, which ensures our neighbors are not harmed, the community is made whole, and harmony amongst our collective communities is preserved. This bipartisan bill is supported by our neighbors, Baraga County, the Village of Baraga, the Village of Lance, as well as the Governor of Michigan. In closing, the tribe would like to express our utmost gratitude to Senator Peters, Senator Stabenow, and Congressman Bergman for introducing the KBIC Settlement Act. Enactment of the KBIC Settlement Act would mean that KBIC is finally compensated for the taking of our lands, our neighbors would gain clear title to their lands, and the state and federal government would right an historical wrong. Miigwech, thanks again for holding this hearing, and I'd be happy to answer any questions.
Thank you very much. Ms. Bryan, please proceed with your testimony.